However, I have spoken with Mr. Edwards, and there appears to be a breakdown in communication between Mr. Edwards and our office. He does not believe that we are fighting in his best interest, and we are asking that our office be withdrawn because I do not believe that this breakdown is something that's going to be. So we're asking to have our office withdrawn and new counsel appointed.
Right out of the gate, we're not easing into anything. We're diving straight into a defense attorney asking to withdraw because of a breakdown in communication. And that phrase? In courtroom language, it's serious. This isn't just, we don't get along. When a public defender says the relationship has deteriorated to the point where representation is compromised, that signals a constitutional concern. Every defendant has the right to effective assistance of counsel, but not the right to shop for attorneys until they find one who tells them what they want to hear. Now watch Judge Simpson closely. He's measured, direct. He's already dealt with this before. And when a judge says, we went through this the last time, that tells you there's history here. So the real tension becomes this. Is this a legitimate communication breakdown, or is Mr. Edwards trying to control the narrative by replacing counsel who won't follow his strategy? And here's the twist. Even if the attorney believes the request lacks merit, if communication truly collapses, representation becomes impossible. So what does the court prioritize? Efficiency, fairness, or constitutional protection? Stay with this one. It escalates fast.
Mr. Edwards, what's the problem?
Beg your pardon?
What's the problem?
I believe the attorney can answer it better than I can legally.
Can what?
He can answer that better than I can.
Are you asking to have counsel removed?
Yes,
Why?
it's been a breakdown in our communication.
What's that mean?
We disagree with things we can't see eye to eye. I have yet to go over with him the discovery, everything that this case is about.
I don't know what that means. You haven't had a chance to go over it with him?
He hasn't went over it with me.
Pardon?
He hasn't went over that with me. Any of my requests is, a matter of fact, he had told me that I could get my, transcript or the paperwork. I don't know the legal terms to put it in today.
That you could get your discovery today? Is that? You're not going to go through trying to pick attorneys, Mr. Edwards. I think we went through this before. Yeah.
I'm so sorry. Ms. Hightower.
Well, I'm going to have to see a motion. I don't understand what this is about. We went through this the last time. I told him to listen to you. You didn't want to listen to him?
I did listen to it.
And so what's the problem?
That's why I said that he can explain it better. Because like you said, there's a breakdown. You can't understand it from me. And so maybe he can tell you in the terms that you'll understand.
Mr. Brown, without
Revealing,
yes. What's the problem?
Your Honor, I've had several visits with my client. And the upshot is he has made it clear that he does not believe that our office is working in his best interest. He does not believe that we are trying to help him in this case.
Right. My question is, in your opinion, is there a valid reason for his insistence in not wanting your office? I don't need to know the specifics. I'm just asking your opinion because it just sounds to me like he just wants to complain.
Well, of course, Your Honor, from my point of view, there's not a valid basis for what he's saying, but there is the fact there is a breakdown in communication. He simply will not take my guidance or my advice, and whether or not it's based on anything that's substantive or real, the fact is, if he's not taking my guidance, not listening to me, and not hearing what I'm having to say, then that constitutes a breakdown in communication that I can't overcome.
This is the key moment. Defense counsel makes it crystal clear. The issue isn't incompetence. It's refusal to follow advice. That's huge. Attorneys don't control every decision in a case, but they do control legal strategy. If a client refuses to listen entirely, that attorney is ethically stuck. They can't present arguments they don't believe in, and they can't fabricate positions just to satisfy a client. Judge Simpson reads between the lines quickly. Like he even reframes it, so he's making it impossible for you to work. Notice the attorney avoids saying that outright. That restraint matters. It keeps professional boundaries intact without publicly attacking the client. But here's the bigger question for you. At what point does distrust become self-sabotage? If you don't trust your lawyer, do you replace them? Or do you risk losing someone who understands your case? And in a system already overloaded, how many times should a defendant get that reset button?
So he's making it impossible for you to work. Well, you don't have to say that. That's my conclusion.
I got very much.
All right, well, we'll have to try to find an attorney then. So take him back, and then we'll bring him back out at some point and figure that out. I need the formal motion before me, so it's got to get here.
All right, thank you, Your Honor. We can do that.
Or to pass that, I have a written motion before me allowing the public defender to withdraw. I'll be honest with you, I don't necessarily see a need to do that. I think the defendant's kind of picking and choosing his attorneys. I'm going to allow it this time. Mr. Kilowald's been appointed to represent him.
All right, thank you, Your Honor.
Esteban,
Yes, it's a motion for bond reduction. I think he says he doesn't have a prior record except for one OUIL, and that he came here in compliance with the court order, except,
after drinking, yeah,
he had been,
which he's not supposed to be doing.
right, he had
So why would I lower his bond?
Now we shift into bond reduction. And this is where accountability collides with sympathy. The defense argues he's not a habitual offender, that he's in shackles, that he's learned his lesson. That's emotional framing. It's meant to humanize him. But Judge Simpson zeroes in on the violation. He was drinking when he wasn't supposed to be. Bond conditions are not suggestions. They are court orders. When someone violates bond, especially involving alcohol in a domestic violence case, the judge has to consider public safety first. And then the record drops. Prior DV from 2010, multiple OWEs. That changes the temperature instantly. You could almost feel the courtroom shift, because now it's no longer one mistake, it's pattern evidence. So here's the engagement question. If someone says they've learned their lesson, but their record tells another story, who do you believe? The words in the courtroom or the history on paper?
I think there's a chance that he'll prevail on the underlying case, the domestic violence. And I think lastly, having been in here, look, the man's in shackles. For a person who's really not a habitual or a regular, he's in handcuffs and shackles. I think he learned.
That's the way we transport.
I know, but I think he learned his lesson.
Yeah, I did.
You want to speak? Speak for yourself. Speak.
Yes, Your Honor. I learned my lesson. Then plus, if I want to get out so I can try to take care of my business at home, and I could, if it could, I would pay $500 to get out. But that's
He's saying he's requesting 5,000, 10%. That's what he's trying to add. Thank you.
Go ahead.
That's all I have.
Your Honor, I did have an opportunity to discuss the bond violation with him. He did appear remorseful and understood when I explained the violation. He did admit to the violation and would have no objection to being placed on a sober link or a SCRAM tether of any kind to ensure he maintains his privacy.
Well, I agree with that. And in addition, I'm sorry, I forgot one fact. He has family support. I've spoken with his sister since I've been here.
Clarify one thing for the record. He does have priors. He has a DV from 2010 as well as multiple OWIs.
Well, I heard of one.
Well, the one from 2003 is the second, so you don't get that stuff first.
Oh, I didn't know nothing about that.
I don't have anything to add. He said he did.
Good. Motion for bond reduction on both matters is denied. Bond will continue. Thank you.
Bond denied. And notice how swift that was. Once the judge confirmed prior offenses, the emotional appeal lost traction. Judges must weigh risk of reoffense, flight risk, and community safety. Prior domestic violence and alcohol-related incidents heavily tilt that scale. What's interesting here is the judge's tone. Calm, almost clinical. No anger, just decision. That's often more powerful than a lecture. It signals this is procedural, not personal. And when defendants hear bond will continue, what they're really hearing is time. More days in custody, more pressure, more consequences stacking.
Excuse me? Really? Yeah. Ow. Go back out. Bye. Thank you. Go ahead, Mr. Vincent. No, I'm good. Go. Anybody else got any names they want to yell out? No? Good. Go ahead, Mr. Vincent. What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work, and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you
Man,
go.
I was gonna try to get you. I was gonna try to get you out of the room. Bloom, I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least
And
I'm
you
not.
said,
At least I'm not driving with a suspended license.
I have no comment.
Okay. Two times now I've let it go. Remember?
Let what
Last
go?
time I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that, I let it go. But Your Honor, today I need to put something on the record. This is very
You
serious.
put something on the record all the time. Go ahead.
Okay, no, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any, there's a lot missing from discovery still. Remember, since October, we've.
No, I remember you
Tooth and
mentioning
nail.
it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why. Listen, Mr. Bernstein. Which discovery referencing, Jeff?
Hospital report that Deputy Soyring says there was a hospital report. There was, I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report.
Mr. Bloom.
Okay, I'll let it go. I'll let my attorney.
Because you keep asking me questions you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
Per transcripts.
Transcripts.
No, I still haven't received the transcripts.
Of what?
3-6. Remember I asked for the transcripts from 3-6? I still haven't received transcripts from 3-6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney, tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants. I have individuals that I work for that are professionals. So I don't know what you have, but I don't
professional
have
for
that.
real.
But go ahead.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing, and someone in my office we did a transcription of it for Jeff. But I think what he wants me to request is an actual transcript, and I just did it that way for speed and
so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen. So,
Thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff's 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy says.
hold on a second. What are you reading to me right now?
Something that I want to state on record, Your Honor.
No, but what you're obviously stating what somebody else said. I'm just
No.
trying to figure out where it's coming.
You said,
On the 24th of,
no, on 10/4 of 22.
in this case?
No, you stated that you believe everything a Washtenaw County Sheriff's deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority of authenticity and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be
Okay,
in
well,
regard to your
I'm
other
trying to
matter
put-
because
I'm
this
trying to
didn't
put
start.
canons.
No, stop. This case didn't start until 10/18. So if you're referring
Okay, I'm
to a
past that.
record from another case,
Then I'm past that.
then you're past what?
I'm past the other case. Here we go. This is this case. Canon 2, Canon 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court. It is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
This moment is explosive, but subtle. Mr. Bloom is now invoking judicial ethics canons on the record. He's essentially implying improper ex parte communication. That's not a small allegation. That's a direct challenge to judicial integrity. However, context matters. The judge immediately clarifies, any communication regarding dental work was disclosed to both parties. Disclosure cures ex parte concerns. Ours said the law doesn't prohibit communication entirely. It prohibits undisclosed communication affecting fairness. Here's where courtroom strategy can backfire. When you start citing ethical rules without tight factual grounding, you risk losing credibility with the bench. And credibility is currency in court. Once it drains, it's hard to rebuild. Would you raise a judicial ethics issue publicly if you weren't absolutely certain? Or does that risk overshadow your actual defense?
No, that was regarding your dental.
Yes.
Yeah,
Yes,
has
that was a
nothing to
motion
do
we
with-
filed.
No, but that has nothing to do with the case.
But I mentioned that on
And
other things you did
but
that.
Mr. Bloom, no, Mr. Bloom,
You don't
because
wanna
if you're
hear it.
going to, you don't want to hear, I don't. Because what you're
know.
saying is incorrect.
Okay.
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
There were other
But-
matters you did the same thing, Your Honor.
Bye.
I'm not contacting
Goodbye.
senior
Goodbye.
commission.
Goodbye,
I'm not
Mr. Bloom.
contacting-
Goodbye. Thank you. Have a great day.
Ride your horse.
Take care.
Where you're at. We'll contact the senior commission, sir.
Have fun. That went south. What are we doing?
Your Honor, there is a resolution in this matter to which Ms. Wilson will be pleading to added count 2 of operating while visibly impaired, and in exchange, count 1 will be dismissed.
That's an operating while visibly impaired.
That is correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Angel Wilson.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to $300 fine plus court costs.
Now we pivot to a completely different defendant, Angel Wilson, and the tone shifts dramatically. This is a plea hearing, and listen carefully to the judge's advisement. Maximum penalties, fines, court costs, rehabilitative services. This is textbook rule compliance. Judges must ensure pleas are knowing, voluntary, and intelligent. The key element here, operating while visibly impaired. That's distinct from high BAC charges. Botch and the state doesn't need a sky-high number. They need observable impairment. And then the crash, a rollover on the freeway. That didn't spontaneously happen, as Judge Simpson bluntly says. That's judicial understatement with edge. When someone admits they don't remember how much they drank, that's a red flag legally and practically, because impairment doesn't start at memory loss. It escalates there.
The court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, order any rehabilitative services or community service the court deems necessary. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consumed intoxicating liquor?
Yes.
What did you have and how much?
I don't.
You don't remember?
How much alcohol?
Okay, how much?
No.
What did you have?
Tequila.
Tequila? Were you stopped by the police or was there an accident?
An accident.
What happened?
The car rolled over.
Pardon?
The
You
car.
need to speak up, young lady.
The car rolled over on the freeway.
All right. That didn't spontaneously happen. What did you do?
I lost control of the vehicle.
And you rolled it.
Yes.
Did the police and paramedics arrive?
Yes.
Were you taken to the hospital?
Yes.
Were you given a blood test?
Yes.
What were the results?
That I don't.
Was it 0.84?
The defense would stipulate to 0.84, Your Honor.
Do you have any reason to dispute those blood test results?
Oh, yes, I do agree.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
That yes seals it. Once she acknowledges impairment, the factual basis for the plea is complete. The court verifies elements: operation of a motor vehicle, consumption of intoxicants, impairment. That's the trifecta required. And notice the defense stipulating to the blood result. Even though 0.084 isn't dramatically high, it crosses statutory thresholds in many jurisdictions. Combined with a rollover accident, impairment becomes difficult to dispute. This is where plea bargaining comes into play. Count 1 dismissed in exchange for pleading to count 2. That's leverage negotiation. Fewer charges, more certainty. Question for you. In a case involving a crash, would you risk trial or accept a plea that caps your exposure?
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 10th at 9 a.m.
July 10th, 2024, 9 a.m. I have another bond resolution.
Yes, Your Honor, and I have discussed that with Ms. Wilson. She does, and I have then reached out to Community Corrections and then got the actual SCRAM report from that company. I did discuss it with Ms. Wilson. She does dispute both drinking and a tamper. She did provide me proof that she was at work as a CNA during that time. Further, both in the bond violation report I received from SCRAM, as well as my client confirmed, she received a new SCRAM tether on May 28th due to it was either a software update or some sort of malfunction. She had 0 violations for the entire month of May. She got a new tether on May 28th. And then on May 31st, there was an alleged tamper that started at, I believe it was 7:10 a.m. in the morning and stopped at 10:29 at night.
Now we enter technical territory: SCRAM tether violations. These devices monitor alcohol consumption transdermally. Tampering alerts can indicate removal, obstruction, or malfunction. The defense raises a legitimate argument. New device issued May 28th, alleged tamper May 31st. 0 prior violations. Employment records showing she was clocked in at work. That's strategic defense lawyering, introducing doubt about device reliability. And in bond violation hearings, when the burden isn't beyond a reasonable doubt, it's typically probable cause or preponderance. Much lower threshold. So even if malfunction is possible, the judge must assess pattern, and that's where prior alcohol violations enter again.
During that time, my client was at work from 6:54 a.m. to 3 p.m. She denies drinking
What
whatsoever.
time did the accident happen?
I'm sorry?
The offense, what time was she at work there at that point too?
So, Your Honor, it was at 4:20 a.m. was when law enforcement arrived on scene.
So early morning doesn't really matter, does it, counsel?
She was at work, Your Honor, and did provide me a screenshot that she clocked into work at 6:54 a.m.
And so, go ahead, I'll let you go.
We would be requesting a formal hearing as to the bond violation. If the
Okay,
court
she'll
is-
get her hearing, but she's gonna be remanded pending that. I mean, I already have had a violation in this case.
I understand that, Your Honor, and I understand she was remanded and served 5 days for that back in April. She denies alcohol use. Quite frankly, I do believe her, and I believe that this may be a malfunction with SCRAM. She did receive this new tether just on the 28th, and the 31st is when the alleged tamper occurred, and the alleged tamper ended at 10:39 p.m. at night. She still has the SCRAM tether on. There has been no further alleged tamper. Further, she has been to urgent care this week due to a medical issue that I won't go into too much detail with. I did provide a copy of the doctor's note that she received from that urgent care to Your Honor. We would respectfully request that if the court is leaning towards taking any action, that we set this for a bond violation hearing and that bond continue in the interim. She did enter a plea in this.
That would be fine, counsel, except for the fact that I'm now on my second violation, both involving alcohol. You want me to ignore the fact that the original incident was one where she was drinking, rolled a vehicle. She's lucky to be alive. Then I put her on this. She comes for this charge. She's drinking. She serves her time for drinking. I'm back and I now have another violation.
Yes, Your Honor.
How, in what responsible world would I let her bond just continue pending a hearing?
This is the turning point. Judge Simpson lays out the narrative. Rollover crash while drinking. Bond violation for drinking. Now another alleged violation. Judges look for patterns, not isolated excuses. When he says, "In what responsible world?" that's rhetorical, but it's also jurisprudential. Judges are guardians of public safety. If someone repeatedly violates alcohol conditions tied to dangerous conduct, the court's tolerance narrows quickly. Defense argues malfunction. Not judge sees repetition. Two competing narratives. Which one carries more institutional weight? History often wins.
She denies alcohol use, and we believe it is a tether malfunction, and you're asking for a hearing on the matter. She did enter a plea for this underlying offense and the alleged incident, and she is willing to face penalties for that.
Yeah, because, well, give me the in custody sentencing date, first of all. Changing your sentencing date, what?
June 25th at 9 a.m.
Sentencing will be June 25th, 2024 at 9 a.m. We will move that up. Got a time for a bond hearing I can do. The 25th, my bond hearing date. That's my date that I have. Right.
The 25th is the sentencing. Yeah.
Well, but the 24th, we have trials and
Yes.
right? We'll set a bond hearing on this matter for June 24th, 2024, 9 a.m. Pending the hearing, we'll be setting the amount of 10,000, make it 5,000 cash.
This courtroom session gave us two powerful themes: breakdown of trust and breakdown of compliance. In the first case, communication collapse forced attorney withdrawal. In the second, alcohol violations eroded judicial patience. Judge Simpson consistently emphasized accountability over sympathy. Legally, we saw key procedural safeguards: motion to withdraw standards, bond reduction criteria, plea colloquy compliance, SCRAM violation arguments, and judicial discretion in remand decisions. Yet emotionally, we saw frustration, denial, negotiation, and consequence. The broader takeaway? Courts operate on patterns. One mistake may earn leniency. Repetition narrows options fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.